I'm attorney Phil Giacino, and this is WLINY's Finding Common Ground here on Altice. You can see Finding Common Ground every Saturday at 10 a.m. on channel 115, and also for you insomniacs at 1 a.m. on Thursdays, channel 20. You can also see another version of Finding Common Ground. We delve into the political on that particular show. It's a half-hour show, very fast-paced. We have calls that come in. We have a chat room. That is every Friday at 8 p.m. Eastern Standard Time. Let's get to it. Got two topics tonight. The first topic will be about the SAT, Scholastic Aptitude Test. Every high school student, well, I shouldn't say everyone, most high school students take the test. There's also the ACT test. And they have a thing now, the College Board is trying to introduce, according to the Wall Street Journal, a thing called adversity scoring, where you get your score for taking the test, and you also get points or lose points depending on whether you're privileged or whether you're not. The second topic is a very interesting story, something right out of Suffolk County here, where a man named Keith Bush, who served 33 years in prison for a crime it looks like he did not commit. He got out in 2007, and years later, also with the help of District Attorney Sini, I want to give him a lot of credit, because you'll find out, once I get into the story, how the District Attorney's Office potentially could help him be cleared of that rape and murder conviction from 1975, based on new evidence and a whole host of other things. But also, one of the factors was the Conviction Integrity Bureau set up by Sini when he became District Attorney. And I believe in a few days we're going to know one way or the other whether or not that board will clear him and seek the conviction being vacated. Let's start with the SAT. The SAT, as I said before, stands for Scholastic Aptitude Test. It's supposed to measure your aptitude. Not like a history test or an English test, but it's a standardized test that colleges use in addition to your grades to decide who gets in to a particular college and who doesn't. The College Board and the chief executive is a guy named David Coleman. You may have heard his name before. He's the architect, he was the architect of Common Core, which a lot of people, including myself, have no use for. But he came up with this thing called adversity scoring. Now, what is that? It's a score between 1 and 100. And if you are there are higher levels of hardship, you'll score higher than a 50. You might get a 60, 70, all the way up to 100. If you're privileged, it'll in all likelihood go down from 50. So I don't know if someone can get 100, maybe they can, not too often, or a 0. But the test is from 1 to 100, 50 being the average. Now, there are 15 factors. Now, we don't know, they don't report what all the factors are, but they look at things like neighborhood crime rates. They look at poverty levels. And again, using that 1 to 100 score. Now, in my book, and I'm not a fan of this, it's arbitrary, and it's also secretive, because the student will never know how many points they pick up on the adversity scoring. They'll just know their SAT score. The colleges, of course, will know what that is. But who's coming up with this test? Is it Coleman by himself? Are there other people? I'm sure there are other people. And how do you weigh it? In other words, one person might say, well, the person's a particular minority, maybe they get more points. It's not supposed to be based on race, but how do you know it doesn't delve into that? Or, oh, he comes from a broken home, so he gets a higher score than somebody that didn't come from a broken home. Now, the big problem I have with this is fairness. And I have a couple of examples. Let's say they go by the home life. So they might say, well, you have more adversity if your parents are divorced than if your parents or you're from an intact family. Not so. Let's say your parents are divorced. You have a student whose parents are divorced. They get along great. The child sees mom, the child sees dad, very comfortable in the arrangement. Can see mom and dad whenever they want. There's no fighting, there's no custody cases in family court or Supreme Court, and the child is well adjusted. Is there any adversity here? Maybe not. What about a child that comes from an intact family, but the parents are like George Costanza's parents, Frank and Estelle, where they're always yelling, they're always at each other. They're not divorced, but maybe that child has a higher level of adversity because it may be intact, but it's not a happy home. There's a lot of yelling, and in some cases there's more than that. There could be abuse. So you don't know. You're never going to know. The person who comes up with the test, it's not like they're going to interview the family and say, oh, your parents are divorced, are you happy? Well, your parents are not divorced, are you happy? That doesn't happen. So they're going to look at things, and how much is that weighted? Is that 50%? Is that 2%? Is it 1%? We don't know. So in a case like I just gave, the fact that parents are divorced or not may not matter. In fact, it might be reversed. Or take a situation where you have a family with means, but they live in a lower socioeconomic neighborhood. Maybe they have the nicest house in the block, but they live in a town that's not known. Like my kids went to Three Village in East Setauket. That's known to be a good school. Smithtown, I went to Smithtown West High School, known to be a good school. Long Island has a lot of good schools, and some schools that are not as well known or not looked at as a Three Village or a Smithtown West or Comac or something like that. So what if the parent with money lives in a neighborhood, or parents live in a neighborhood that's lower socioeconomic? Does that rich kid, if you want to call him that, because he has means, he just happens to live in a lower socioeconomic neighborhood, does he get points? What about a kid who's poor? His family is poor, but he lives in, let's say, the Three Village area, and he goes toward Melville. Would you say he has less adversity because he goes to, let's say, a better high school than the richer kid who goes to a lesser high school? I don't know the answer to that. And how does the person coming up with that score, how could they ever know what that student is experiencing just by broad strokes? Say, divorced, or good neighborhood, high crime rate. A neighborhood or community could have a high crime rate, but let's say this particular kid lives in a gated community within a particular neighborhood. It's a totally different thing. Now, what about a situation where a family recently moved on up, like in the Jeffersons, moving on up? Is there a look-back period? So maybe that kid had adversity his whole life, and then his family came into some money and moved into a nice neighborhood, and they've been there for 6 weeks. And now the kid's taking the SAT. Do they say, oh, the kid's in Muttontown, so he had no adversity? But that's not true, because his whole life may have been diversity until his parents became successful. It could have been an inheritance. It could have been they won the lottery. It could be he had an idea that finally caught fire, and now he was able to move his family from a lesser neighborhood to a better neighborhood. That's a good example, I think, of a situation where that kid may lose out and not get adversity points, even though that kid is deserving, if you're going to believe in that score. And in those examples, who gets the points, how much? And when you give points to one person and taking them away from another, that's not necessarily fair. Because when you help somebody, you could also be hurting somebody else. Because you might have a kid, a middle class, or let's say a kid that doesn't have much diversity in his life, but yet he worked his butt off, got good grades, did what he had to do, stayed out of trouble, and he might only get a 25 on that score. Whereas another kid who bummed around, didn't really work hard, but comes from a lower socioeconomic neighborhood, maybe with high crime rates, and he gets a 90. He might get into the better school, assuming the test was similar, the raw test of the SAT. But that kid may get into the better school where the other kid who worked harder doesn't, simply because of an arbitrary score. Now, I grew up in Smithtown. I went to Smithtown West, class of '82. I can honestly say, in my life, I didn't really have adversity. I didn't have adversity. Well, growing up in Smithtown, there wasn't a lot of diversity to begin with, but I didn't have adversity. I had two parents. We were middle class. I never went hungry. You know, we had what we needed. So I can't say, I went hungry or I lived in my car. Like, I've heard stories. I've had clients where they say they grew up poor and they faced a lot of adversity. Do I get 0 and maybe not get into the school I want to get into because somebody got a higher score arbitrarily because they grew up in, and I won't even mention any towns, but a town that has a higher crime rate than Smithtown, or a higher poverty level than a Smithtown? I always say that doesn't seem fair. I'm going to use a sports analogy. Let's say there's a track meet and one of the runners has a bad hamstring. So they get together and they say, you know what? He's usually a fast guy, but today he's got a hurt hamstring. We're going to give him a lead. We're going to move the blocks up. Let's say it's a 100-meter race. We're going to move the blocks up 5 meters. So he will get a better start than the other racers, runners, who don't have a bad hamstring. You would never see that. That would never happen. Either the guy would run or the female would run their race the same as all the other runners, or not, if he or she was not able to run the race. Or, it sounds ridiculous, but let's say you have a guy who's a basketball player and he's 5'6". And you know there are basketball players 6 feet, 7 feet. Does that shorter basketball player get to shoot at a lower hoop? Of course not. That would be ridiculous. You wouldn't do that. You play the game by the rules. But they're changing the rules with this adversity score. You know, at first blush, it might sound nice. Oh, give somebody that's disadvantaged a leg up. But when you do that, you could hurt somebody else. And you could have that student get into a school that he or she shouldn't be in. Right? Not everybody can go to Harvard or Fordham or Hofstra or wherever. There are really good schools and there are schools that are lesser schools. That's why to get into the better schools, unless you have a rich dad who's putting a wing on a school, you got to have the numbers. There are exceptions. You know, obviously, if you're a great athlete, you can get into a better school. If you're a star quarterback, you might get to go to Columbia, whereas if you're a lousy athlete, you're not going to that school. But leveling the playing field is not always the answer. And I knew firsthand when I went to school that there was a student that got into this school that didn't have the grades, and they didn't make it. They failed out. Had that person not gone to the school he was going to, and he went to a school that maybe was easier, let's be honest. There are some schools that are very, very, very demanding, and some that are lesser. Had he gone to a lesser demanding school, he could have thrived and done better, instead of going to a school that he wasn't able to get through. And that happens for all different reasons. It's not always race, color, creed. No. It could be you take a student who is fairly smart, but not Harvard smart, or not Fordham smart, or not whatever. There is a school. Same as a team. Let's say you love playing a sport and you're decent, but you're not great. You're not going to go to a Division I school and play, let's say, baseball. You might choose a Division II school or Division III. Nothing wrong with that. You can still play ball and have a good time. If you look for the government to level the playing field, or a bureaucrat, in the case of the College Board, a bureaucrat, if you look for someone like that to level the playing field, you're going to be severely disappointed. They can't. They can attempt to do it, but they can't. They won't be able to. That's why, and I'm going to draw an analogy, that's why capitalism works, not perfect. Some people fail under capitalism, but socialism is a failure, and it doesn't deliver economic prosperity, even though a number of people running for president as Democrats believe, like Bernie Sanders, believes that it does deliver. Right? It's almost like, if I can liken it, where they're going to give adversity points, they're trying to spread the wealth around, so to speak. Right? Instead of saying, all right, the best and the brightest go to this school, and the ones that are in the middle go to this school, and the ones that are lesser go to this school. Capitalism is you sink or swim on your own. You get out there, you get a job, you do what you have to do. Just look at Cuba, for instance, or Venezuela. Venezuela was a rich country not that long ago. had vast oil reserves, and now it's like a third world country. They're rioting, people are eating out of dumpsters because they went to socialism. And that's a fact. It failed for them. Their shelves have no food on it. It's very bad there. People want to overthrow the government. Why? Because it's one thing, America, we're lucky. Whether we have a Republican or we have a Democrat, we're not going to have, for the most part, rioting in the streets. We're not going to have the government come out and put down a rebellion. Not yet. So whether Hillary won or Donald Trump won, we would still move forward. We are a nation that would be wise to heed the warnings from countries like Venezuela and Cuba. Because Cuba has always been Cuba, but Venezuela wasn't. As I said before, Venezuela was prosperous. It's not prosperous anymore. Give you an example of that kind of thinking. Bill de Blasio, who is now running for president as a Democrat, and he's the mayor of New York, he said the other day, maybe about 2 weeks ago, 3 weeks ago, there's plenty of money out there, but just in the wrong hands. Think about that. There's plenty of money, but in the wrong hands. What's the wrong hands? We're not talking about some crime family or some drug cartel. Honest people, they may be billionaires, they may be millionaires. Who is Bill de Blasio to tell us whose hands that money should be in? Who is he to do that? Now, in an attempt to level the playing field, unintended consequences often happen. And it happens in a lot of things. You try to do something good, but there's an unintended consequence. You want to raise the minimum wage? Yes. Okay, somebody's going to make $15, but other people may lose their job or the company may go out of business. An unintended consequence. The person who came up with $15 an hour didn't intend for people to lose their job. It just happens. And we see it over and over again. It's in the news on a regular basis. A company or a shop closes down because they can't afford to pay everybody $15 or as a minimum wage. Now back to the SAT. So you could have a kid who works his or her butt off and they could be penalized by that test. Now, I have no problem with a school, a college, any school that decides, unlike a public school, it could be a private school, where they decide who gets in and who doesn't. Public, it's different. I have no problem with the school deciding on its own, on a case-by-case basis, still with quality control in place, that they can take, let's say it's a close call, and one student maybe had a lot of adversity or overcame a lot. And they say, let's have some diversity in the student body. I want to pick that kid over the other kid. They can do that. And it's done all the time anyway. We're blind to think it doesn't happen. Of course it happens. It happened when they had affirmative action. It happens now. That's why a number of Chinese students are suing Harvard, because they said, we're getting excluded. Because so many Chinese people are looked on as great students, they're doing well. And now the school's like, we can't have 50% Asians, so now let's not take some of the top ones and we're going to get other groups. Right? That's why there's a lawsuit. Because when you help somebody or lift up somebody, you could be lowering somebody else. So to me, that adversity score is a scheme. It should not be followed. I hope it goes away. The next topic I want to talk about is a fascinating cautionary tale. It's about a man named Keith Bush, who in 1975 was accused of raping and murdering a 14-year-old girl after a party. Her name is Sharice Watson. I think Belle was 17, I believe, at the time. He was arrested, and in 1976, he went to trial here in Suffolk County. He was convicted, sentenced to jail, and he ended up serving 33 years. He could have been out, according to his defense attorney, 12 years earlier, but he kept maintaining his innocence. So when he went before the parole board would say, well, you're not taking responsibility for your actions, so we're not letting you out. So he could have got out years earlier, but he couldn't admit to something he didn't do. Now let's look a little bit at the background. There was no DNA that convicted him. There was a witness named Maxie Bell, 14, might have been a friend of the victim. She was at the scene, or at the party, and she testified against him. Now, I didn't see the transcript, so I don't know exactly what she said, but she was a key witness that convicted him. Some years later, she said, I lied on the stand. I was afraid of the Suffolk County Police Department. Now, this is going back to the police department of 75, 76. And the Detective Rafferty was the lead detective. And they brought her before a judge in 1981, and the judge said, no, I'm not buying it. We're not overturning the conviction. Right. But the main part of this story that I want to address is in this particular case, and I've mentioned Brady material many, many times on my shows. Brady material, very simply, is any material, documentation, information that could exculpate the defendant, person accused, or be used for impeaching a witness, or used in the punishment phase. I'll give you an example, quick example of that. Let's say a man comes home and finds his wife with another man, and he beats the guy up. Right? That's still a crime, but that might be different than a guy that goes out, steals a man's wallet, and beats him up. Right? Those are two different situations where the judge should give one, the guy that stole a wallet and beat the guy up, a more harsher punishment than the guy that, let's say, a crime of passion. Still a crime, but the sentencing, one guy might get 5 years, another one might get 1 year. It all depends. So that's Brady material. The DA has to turn that over. And unfortunately here in Suffolk County, there's been problems in years past on some higher profile cases where the DA didn't turn over. I have a case, a civil case right now, and I represented an individual in a criminal case where there were Brady violations. Now, you don't always know about it unless somebody comes forward. In the civil case that I have, it was because my client, before he even hired me, filed a lawsuit and some information came his way. That's how he knew that the DA held back. Whether it be intentional or not, you have to turn that documentation over. In 2017 and 2018, his attorney, and through the years, he got out in 07, so he's out of jail. But when he got out, he still wanted to clear his name. He said, I didn't do this. And in fact, there was a confession, but he said, I never confessed. They beat me up. He said it was nothing short of torture that got him to say things that he didn't mean. He said Detective Rafferty kicked him in the groin, and he said other officers hit him, beat him with a phone book, and that was something that they did years ago. Now you don't have a phone book, but years ago that it came out that a number of confessions were obtained by the police using phone books because it didn't leave a mark, but yet it would cause a lot of pain, and these people would say things they didn't mean. They didn't do the crime, but they just wanted to be done with being hit. So they made a confession of some kind, give a statement. Right. I think nowadays, and digressing a little bit, you should have especially in these serious cases, every confession videotaped. So a jury can look at that if necessary, if it goes to trial, and say, I believe the guy is telling the truth, or I see he's under duress. I don't believe that is a true confession. Tape it. You can get a camcorder for next to nothing at Best Buy. Use that and tape it. So here we have, he says he didn't give a confession, but yet they said he did. There was a witness that apparently was intimidated that testified against him that came out later. So you have two things. But the biggest thing, as I just said before, is Brady. I'll give you an example of Brady material. Let's say there's a shooting and they arrest a white male who's 6'2", and he's the defendant. And then the DA or the police first get a statement from a witness that said, I saw a 5'5" Chinese man running from the scene right after the shots were fired. That is Brady material, textbook Brady. That has to be turned over to the defense attorney. So if the police give it to the prosecutor has to turn it over to the defense attorney. Now, does that mean in my example that the Chinese man fired the shots? No, it doesn't. But the defense attorney has a right to get that information. He could bring it up at trial. He could call the witness that saw the Chinese person running to create reasonable doubt. Right? That is Brady material. In this case, Keith Bush, years and years and years later, so it happened in 75, he was convicted in 76, 2017, his attorney had filed a FOIL lawsuit, Freedom of Information Law, and they obtained a statement. Now eventually, with the help of District Attorney Sini, who, as I said before, had the Conviction Integrity Bureau set up, they divulged the name of a man named Watson. I'm sorry, it wasn't Watson. It was an individual that was at the scene, but never went anywhere. They didn't charge him. Right? He didn't testify. The district attorney never told the defense attorney, I have a statement. And it was a statement from this man. He took a polygraph, and he didn't fail it, but there was some deception, that it seemed. But the police were convinced that Bush was the murderer and not this other fellow, Jones. His name is Jones. When it was finally turned over, there were some interesting things that the defense attorney learned. Jones stated that he dropped his comb, and there was a comb at the scene that looked like the comb that he dropped. His words from 75, 76, thereabouts, before the trial. Had a defense attorney knew this, it could have been a different story. In fact, from what I understand, a juror was questioned about that, and they said, had we known that there was another person at the scene who said he stumbled over the body, that could have been a different verdict. Could have been not guilty. Then, years later, they didn't have DNA. They did DNA test on the comb, one of the combs that was at the scene, and it was not of Keith Bush. Now, Jones had died some years earlier, so I guess they couldn't test his DNA. But it wasn't Keith Bush's. Had it been Keith Bush's, that could have put him at the scene of the murder itself. He was at the dance, and he was talking to the girl. There was some testimony that he was angry at her. Maybe she spurned his advances. But to convict somebody, you have to have beyond a reasonable doubt. A statement from this fellow Jones and what he said, had it been turned over to the defense attorney, it could have been a very, very different story. But the big break came when the defense attorney could have made a 440 motion to vacate the conviction. And remember, he's out already, but they want to vacate the conviction. He did 33 years. The defense attorney, instead of making that motion, went to the district attorney's office and brought them what they knew about the case. Sini took a look at it and said, I'll consider it. He did that, and he made a recommendation to an independent body that does their own investigation. He made a recommendation that the conviction should be vacated. Now, it hasn't happened yet, but it may go that way. When you have the district attorney of the county that prosecuted the guy saying, you know what, we have our doubts, this case wasn't handled properly. You had a witness that came forward and said, I lied. All right? You had the defendant say, I was basically tortured. Now, a lot of people, in all fairness, say that, or the cop roughed me up. But that was something that was said. And you have the clear Brady violations. Clear Brady violations. This is not even close. These things should have been turned over prior to the trial so his defense attorney could have used that information to create reasonable doubt. And it would have been up to the jury. And that's how it should be. Maybe the jury would have said, okay, we're not convinced. We heard the statement. We read the statement. But you know what? We still think it was Bush that committed the murder and rape, and that's fine. So it is very, very important that the prosecutor turn over and adhere to their duties as a prosecutor. They're held to a higher standard. There's certain, just like a defense attorney has certain things he has to do. He can't suborn perjury. If a demand is made of him, there's certain things that he has to comply with. Alibi notice and all those things. But the prosecutor, and I've always said this, the prosecutor's office in this county, Suffolk County, the Suffolk County District Attorney's Office is the most powerful law firm. I'm using that term loosely, but in a sense, it's a law firm. It's a prosecutorial agency, but their attorneys, they have over 100, and you have a DA, and they have detective investigators, and they have paralegals, and they have a staff that no one else can come close to. Even the county attorney is not as powerful as the district attorney's office, with the resources they have at their disposal. Even the most powerful criminal defense firm can't match them with resources. I'm not saying that it's not as talented necessarily, but in the district attorney's office, you have excellent attorneys, especially at the higher levels, seasoned attorneys that are prosecuting the murder cases, the sex abuse cases. Then you have at their disposal detective investigators. When I was an assistant DA, we didn't go out and investigate a case. We had detective investigators. So I might say, check out this witness, or do this, or go to that location. We had a staff that we used. Now, with regard to Brady, and I was alluding to it earlier, often the defense attorney doesn't know what he doesn't know. What does that mean? If the DA turns over a few items, the defense attorney believes that's it. He can't drive over to the DA's office and say, let me go through your file, like in My Cousin Vinny. I'm going to go through your file. Let me see if you were honest and gave me everything. No, that doesn't happen that way. But how do you find out? Sometimes things get leaked. In a high-profile case, let's say like an OJ case or a big case, an anonymous call can be made because people know about the case, as opposed to a small case, let's say out in Riverhead, that's not in the papers. The defense attorney will probably never know what Brady violations occurred, unless, like in the case I told you about, where my client brought a lawsuit, things came out. In this particular case, he went to trial in '76, and it wasn't until 2017 that he got information that could be considered exculpatory. I mean, he could have cleared him. So it's very important the DA follow all the rules. And this is not, it's not an indictment on the Suffolk DA's office. Again, this goes way, way back. And in this case, DA Cini did the right thing. He looked at the case. He could have said, nah, I don't care. He didn't. Now, I don't know all what he did. Obviously, what he read, what he learned, was enough for him to say it should be vacated. And an independent body will then decide based on that recommendation. And that's a good thing, because even though he's out of jail, he can live in peace if he knows, especially if he's not guilty, and that's what he's been saying all these years, that he can live in peace knowing he's not a convicted murderer and rapist. What I want to do now is some frequently asked questions. Since we have a criminal theme, we're going to stick with some criminal law topics. One is, what happens if there are no Miranda warnings? You know how we just talked about Brady, and there are certain rules that the prosecutor has to follow, and the police. This is another one of those rules. What is Miranda? Miranda warnings are, and you've all heard them if you watch TV, you have the right to remain silent. Anything you say can and will be used against you in a court of law. You have a right to an attorney. Those warnings are given to any person who's under arrest or who's in custody. Now, custody could be a number of things. Custody could be you're handcuffed in the back of a police car. That's custody, even if you haven't been arrested yet. Or it can be you're pulled over, let's say, and a cop says, get out of the car, go sit down on the curb and don't move. That, in a sense, is custody, because if you move, You could be arrested. You could be handcuffed at that point. You're told by a police officer, don't move, as opposed to you sitting in your car and you're just asking you questions. So there, you'd have to be Mirandized. Sit down, don't move. If he wants to take a statement from you, he might not want it at that moment, but if he wants to take a statement from you, whether you're in custody, under arrest, one of those situations, he must Mirandize you and make sure you understand it. If you don't speak English, he has to get somebody to read the warnings to you in your native tongue. If it's Spanish, Spanish. Because otherwise, if he says it in English, it won't matter. So the person would get Mirandized so that if they gave a statement, so if you're Mirandized and you say, you know what, officer, I did shoot the clerk. Like in My Cousin Vinny, remember? I shot the clerk. You kept repeating it. If he was Mirandized, and it has to be used in the right context, that statement could be used. In My Cousin Vinny, we've all seen that, where they were questioning him and say, is that when you shot the clerk? If he had not been Mirandized, those statements, those admissions, would be thrown out because he was in police custody. He was being questioned by the police at the police precinct or the police station. Now, people say to me all the time, you know, he didn't Mirandize me, so the case goes away, right? And I say, no. The statement might get tossed. As I just said in My Cousin Vinny example, the statement would get tossed. But if there's enough to go forward, let's say you have a witness saying, I saw the guy shoot him, or there's a video, or an audio, or DNA. There are a whole bunch of ways a person is convicted. And often it's not because they gave a confession. There's other ways to get a conviction. So just because you were not Mirandized does not mean your case goes away. In all likelihood, it probably wouldn't go away. But the statement could be tossed. I'll give you a quick example. I once had a serious case out in Riverhead that I was trying. And at the Huntley hearing, which handles, you know, the Miranda, the statements, the voluntariness, there's a whole bunch of other things that they consider. Was it made voluntarily? A cop can Mirandize you and then beat you up, and the statement you give can't be used. Just because you Mirandized, it wasn't voluntarily given. So I'm just really focusing on Miranda warnings, but there are other things that follow. So once you're Mirandized, if you give a statement, it can be used. It could be oral, it could be written. It doesn't have to be in writing. The cop could say, yeah, when I Mirandized him, he said, yeah, I shot the guy. That can be used. At the arraignment or within 15 days, you have to serve that Huntley statement. The Huntley statement will be what he said, the confession, what the defendant said. So it could be written, when I get that, it says, yeah, I was drunk. My client might say, I never said that. Well, then you're entitled to a Huntley hearing. Now, if the judge, there's no jury for this particular hearing. If the judge believes the officer that you were properly Mirandized and the statement was given freely and voluntarily, no coercion, the statement gets used. In the example I was about to give, my client was Mirandized while sitting in the back seat. The two detectives were driving on Sunrise Highway, a lot of traffic, so the driver had to pay attention. It wasn't like he was pulled over to the side of the road. And he Mirandized him. Now, my client said, I couldn't really hear everything, and it wasn't like face-to-face where you can better understand what the person is saying. He couldn't really read his lips, too, because he was driving. He was sitting behind him, so he's looking in the rearview mirror, I guess, trying to say, well, what is that guy saying? That statement, after a Huntley hearing, was tossed. They still proceeded with the case. They had other things on him. Confession is always nice to have, but in this particular case, they proceeded without that. I ultimately got not guilty. I was going to say a conviction. The DA did not get the conviction. My client was found not guilty. Now, if they had a statement, it might have helped their case. It might have been a stronger case because my client, I won't get into everything, but may have said things that a jury could take to mean there's a level of guilt or consciousness of guilt or something along those lines. So when you're Mirandized, whatever you say after that, be careful. And one of the other frequently asked questions, which I'll jump right to now, is when you're arrested, do you have to speak to the police? You have to give them your name. You have to give them what I call pedigree, like name, rank, and serial number for like a captured soldier, name, address, and a date of birth. So they can run you to see if you have a warrant, to see if you have any priors, just to find out a little bit more about you. But don't, and I repeat, don't talk about the reason you're under arrest. If they arrest you because of an assault, don't give them a statement. Now, unless you have an airtight alibi, if you, let's say they say on June 1st, you robbed that bank, and on June 1st, you were in Florida, then you might want to say, check it out, I was in Florida. But if that's not the case, don't give a statement, because your statement can be taken out of context. You could be wrong about something, right? You might just be making a mistake. He might say, well, July 1st, and you're going to say, no, July 1st, I was at the Yankee game. But you're mistaken. You weren't at the Yankee game on July 1st. You were at the Yankee game on some other day. So now if this case were to go to trial, or even the DA looking at it, they're going to say, he lied. And you're going to say, well, I didn't lie, I made a mistake. Well, don't speak. Don't give a statement. So you can't make a mistake. You can't be misunderstood. You can't be tricked, whatever. Don't give a statement. Be polite. Some guys are a wise guy. You know, you got nothing on me. Why would you do that? Even if the cop is being a jerk, why would you antagonize him when he has the power to charge you with a number of things, look for other things to charge you with, make your life uncomfortable? Why would you do that? It'd be like being pulled over by a cop and say, officer, I'm sorry, you know, was I speeding or something like that? Humble yourself. You get pulled over. What are you pulling me over for? Other guys are passing by. Come on, what are you busting my chops for? Not smart. He's the guy holding the ticket book. I haven't been pulled over many times, but the last time I was pulled over, I didn't have my wallet on me. I was in my suit driving my vehicle, and I didn't have my wallet on me. I left it in my briefcase back at the office. So he pulls me over, and I had been on my cell phone at a stop. And I said to him, I said, officer, why was I pulled over? He said, you were on your cell phone. I said, well, officer, I was on while I was stopped at right near the centralized train station. I was making a left turn. And he said, you were on it before? I said, I'm sorry, officer. And I said, license, registration, which I didn't have. I gave him my business card. He went back, looked it up, saw that I didn't have a bad driving record at all. And he came back and he let me go. He didn't give me a ticket. Now, if I would have been a smart guy and said something like, what, are you kidding me? I wasn't on my phone, come on. I suspect I would have got that ticket. So be polite, answer the question. Another thing is, sometimes you have the ability to come down to the precinct to surrender. So you're not picked up off the street, let's say. They call, your attorney can work out a surrender. That's the best way to do it, because sometimes you can avoid spending a lot of time in the holding facility. Sometimes I can have my client surrender, let's say 6:30, 7, 8 in the morning, and be brought over to court, the CIA courthouse, and be processed, arraigned, whatever the case might be. As opposed to surrendering 10 o'clock at night and spending the night in jail. Not a fun place to spend your night. Sometimes you have no choice. There, the attorney would call if my client calls me and says, or even, maybe not even a client yet, hey look, police just left this card on my door, I gotta call him back. I call him back and they say, look, we gotta arrest him. Gotta surrender. It's a serious charge, or it's an order of protection. We don't have the luxury of saying, okay, come in tomorrow. They gotta make the arrest. In that case, I would say, okay, I'll surrender. Can we do it in the morning? If we can't, okay, he'll surrender at night. Don't question him about anything, please. Don't. And they won't. If they do, they're violating my instructions. So once they get to the precinct, and what I was about to say is, they should not bring their cell phone. Now again, I don't know if my client's telling me the truth, lying. I don't know what they did or didn't do. A lot of times they say some things to me that turn out not to be the case. I'm not naive. And a lot of times, let's say it's a drug case, they might want to go through the guy's phone and see who he's calling to get other names, other leads. So I'll say to my client, leave your phone home. When it's time to go home, well, you're probably brought to the jail, but even if they released you on station house bail, ask to borrow a phone, walk home. Don't bring your phone in, because they can potentially go through your phone and get some information you might not want them to have. And a lot of times when I get called, if the guy's in custody or about to be taken into custody, I don't always have the ability to assess if what I'm being told is BS or not. So as a general rule, I say leave your cell phone home. Don't bring it. Okay? In a criminal case, whose call is it to get a jury? People always ask me, is it the DA, is it the defense attorney? It's only the defendant, in consultation with his attorney, but it's the defense, the defendant, that says, I want a jury or I don't want a jury. Even if the prosecutor is dying for a jury, he or she, the prosecutor, does not get to request one. And if they don't want one, they can't say, I don't want one. It's not their call. It's the defendant. Now, in a felony case, there's 12 jurors and alternates. In a misdemeanor case, there are 6 jurors and alternates, usually 1 or 2 alternates, depending. If it's a felony, and you have 12 jurors, and the case might be a month long, you might want 2 or 3 alternates, because if somebody gets sick or can't serve, you don't want a mistrial. In a violation of law, so let's say harassment, simple harassment, you would not get a jury. That is called a bench trial. And I've tried some of those where you go to trial, the judge hears the case, and that's it. Now, why would a defendant want a jury or not want a jury? There's a strategy behind it. Now, you see a lot of times in police cases, they don't want a jury because they're afraid the jurors might feel compelled to convict the cop who might have shot somebody they think was an innocent person, or the police overstepped their bounds. So they go with a judge, they take their chances. They hope that a judge will follow the law and maybe not convict them if they follow the proper procedures. If I'm a criminal defense, I am a criminal defense attorney, but if I have a case, I look at it this way. Would the judge, and it's got to be clear to me, would the judge be more likely to find my guy not guilty than a jury? If it's a close call, I'm going with the jury every time. That's my general rule. Go with the jury. Because even in a misdemeanor, the DA's got to convince 6 people. 1 might not agree, 2 might not agree. It only takes 1 to get a mistrial. And I'll be honest with you, I've tried many, many cases. Even when they're deliberating, I had one, they were sequestered for 4 days. You can't really do that anymore. But they were sequestered for 4 days. 20, 30 years ago, this trial was, a long time ago. The jury was sequestered and deliberated for 4 days, and then finally came back with a verdict. Right? So in a situation like that, the jury was deadlocked. They ultimately came up with a verdict. I've never had a case that ended with a mistrial because a jury didn't reach a verdict, for better or for worse. They get the charge, Allen charge, go back. There's nobody in a better position than you 6 or you 12. You listen to the whole trial. We don't have to do this again. Please, come on. And the case I got, it was a felony out in Riverhead. It was a 10-2 for an acquittal. The 2 holdouts eventually changed their vote, and my guy was acquitted. But I look at it and I say, like, I'll give you an example. Let's say in conferencing the case, the judge would have said to the DA, and I'm not saying this ever happened, but let's say the judge says, come on, this case is very weak. Where are we going with this? Give him an offer. Or what are you doing with this case? I might go with a judge, a bench trial, because he's almost telegraphing that he thinks the case is weak. And don't forget, it's beyond a reasonable doubt. So even if he thinks maybe the guy did it, but beyond a reasonable doubt, I might go with a bench trial. It's cheaper, quicker, right? Spend less time on the case, presented, judge makes a decision. Let's say I had that same conference and the judge says to me, counselor, I would take the plea. This is a very strong case. I'm not going with the bench trial. I'm going with the jury trial. Because the judge, in a sense, is telegraphing that he thinks my guy might be guilty, or that the DA has a strong case. So I'd be crazy to do a bench trial if I think the judge is going to find my guy guilty. One of my last trials, I got a not guilty verdict after, it was about a 4 or 5 day trial over in Central Islip. And we really didn't have a lot of conferences, so I didn't really know how the judge would go. But once I said my client wants to go to trial, and it was assault, endangering the welfare of 3 children, not as bad as it sounded, but because they witnessed some domestic violence, or alleged domestic violence. And there was a video showing a woman hitting the ground. It was almost like this Zapruder film. You didn't see the whole thing, but you saw the aftermath of it. And the judge on 3 occasions said to me, Phil, are you sure you want to go to trial on this? Take a plea, I just want you to make sure. And I said, I understand what I'm doing, and I'm confident I can get an acquittal. I was, and I did. But there, I wouldn't go with a judge, with a bench trial, if the judge is saying to me, you know, maybe you should take the plea. Because that's telling me they think that case is a strong enough case to get a conviction. I'm not going to do that. One of the other things I get asked all the time is, what should I do if I'm arrested? Now, we kind of talked about that. Be polite. Leave your cell phone home if you can, or give it to somebody. Don't give out a statement. You don't want to do that. It locks you in. Because then later, if you say, you know what, I really shouldn't have said that, or I was mistaken, or it was the wrong day, you're locked in. It's hard. Then if you get up there, the prosecutor can have a field day with you. Didn't you say you had a Yankee game on June 1st? Yes, but I was wrong. Okay, you were wrong. What about this? What about that? And then they might think that the statement he gave is riddled with inaccuracies or self-serving information. In other words, where you're lying to cover yourself when it turns out you were not at Yankee Stadium on June 1st. So those are some of the things. And of course, call an experienced criminal defense attorney right away. Just like if you're going through a divorce, you call an experienced divorce attorney, someone like myself who handles these kinds of cases, because you don't know what you're doing. Even if you've been arrested before, that's not what you do for a living. If my toilet goes kaput and water's shooting out, I'm not going in there with a wrench. I'm going to shut the water off and call a plumber, because that's not my area of expertise. The expression now is stay in your lane. You might, and I've seen it many, many times, people come to me and they've made mistakes already that make my job more difficult. It could be a confession. It could be a statement they gave. It could be a text they sent out. It could be a whole bunch of things that was just dumb for them to do. But they did it because they didn't talk to an attorney. People come in, oh, I signed that document. I shouldn't have, right? No, you shouldn't have signed it. But you did, so now I have to deal with it. You made my job more difficult. Another question is, what's an arraignment? People say, what is an arraignment? Arraignment is unique to criminal type cases where the judge will 99.999% of the time enter a plea of not guilty on your behalf. Even if you wanted to plead guilty, generally speaking, the judge will say, no, I'm going to enter a plea of not guilty on your behalf. Get an attorney or communicate with your attorney, and then come back on the next court date. Now, at an arraignment, there's also an issue of bail. Now, some lower level cases, it's a no-brainer. You're released on your own recognizance. If it's a murder case, chances are there's going to be high bail. Right? Or if you have a warrant history, let's say you have a habit of not coming back to court. Even though you might not be Charles Manson, you don't come back to court. The judge is going to say, I want to make sure you come back to court. $5,000 bail. If you don't come back, you forfeit the bail. Right? In the more serious cases, you may have to put up a house or something, property, to secure the bond. And you'd pay like a $100,000 bond, you'd pay $7,000 in cash, let's say. You lose that $7,000. And if the person heads for the hills, you could lose your house. Or you could have a lien on your house for $100,000, which is the amount of the lien on the property, the amount of the bond. So an arraignment addresses usually enter plea of not guilty. Sometimes an order of protection is granted there. So let's say a husband is accused of hitting his wife. The wife can come to the arraignment and say, I want an order of protection, or contact the DA, and the DA can make the request. So there's a number of things that go on in an arraignment. That's why it's important to have an attorney. Because sometimes, I'll go in, I'll plead not guilty, that'll be it. No, well, what if they say $5,000 bail? If you had an attorney, it might have been $1,000. Or maybe there would have been ROR, released on your own recognizance, because there's a score they do. When you come in to the court system, let's say you at a precinct, they bring you to CI, they do an ROR score. It's a pink sheet, 3 or 4 pages, and it'll say it's 0 to 11. So if you're an illegal alien, you're going to score 0. If you are someone that's lived in Suffolk County your whole life and you got a job and you own property and you've never been in trouble, you're going to score a 10 or an 11. Easy. So that's why it's important to get the attorney right away to protect yourself. Because even if I only spoke for 3 minutes and I said, get an attorney, get an attorney, get an attorney, you're better off than trying to figure out. You wouldn't go to a hospital and say, give me the scalpel, I'll take care of myself. Don't walk into a courtroom without an attorney. Before we end, I just want to thank you for watching. Again, mention that you can see Finding Common Ground on Saturdays, channel 115 at 10 a.m. or Thursday, 1 a.m. on channel 20, and Finding Common Ground Live, which, like I said, delves more into the political, and I always call it politics, law, and social commentary with an edge, 8 o'clock Friday nights, 8 p.m. I'll be sitting in this chair. There's a chat room, so you can, if you don't call in, you can go to the chat room and put your 2 cents in, and we can mention you and talk about your topic. You could agree with me, disagree with me. That's the fun of it.